Good morning and welcome. It is Sunday, July 12th, 2026, and this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Hello to Becky B and Helen the Scottish Llama and Afton and Mixed Firebird's Child, Jules 4911, Race and Rodeo. It's so glad to see. I'm so happy to see so many of you joining us again on a Sunday morning. It's going to be a good one. It's been a long week. We were out in Provo, Utah all last week for the Tyler Robinson preliminary hearing for the murder of Charlie Kirk. It was a fascinating week. A lot of you had questions on that, so we're going to get into that case as well. It was also an exhausting week, pretty wiped out, but I will tell you, I always look forward to our Sunday mornings together. So thank you so much for joining me. Hello to everybody who's here. Dr. Go Duke Baseball or Basketball says hello. If you are new, and we hope that you are, we've picked up some new followers over the last week. If this is your first Sunday Funday, welcome. I think you're really going to enjoy it. But let me introduce myself if I haven't already. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for about 10 years or so before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential, where we do our best to present to you both sides of the courtroom, both sides of the stories, and both sides of the issues. And this is a show that we call Sunday Funday because it's on Sunday, where we take your questions that you've left us in voicemails throughout the week, and we're going to answer them live right here. So stay to the end. We have some announcements, some new and fun stuff coming up. I don't want you to miss out on that. Crime Connoisseur, 80% juice. We gotta bump those numbers up. I think we can. What was I saying? Oh yeah, stay to the end. We actually do have some new announcements I want you to know about. Some special stuff we put together that I don't want you to miss. But in the meantime, you know what time it is. Take that big, deep, cleansing breath. It's Sunday. You've made it. It's the end of the week or the beginning of the next, depending on how you look at it. Hit that like button if you haven't already. Subscribe if you haven't already, and share this with anyone that you feel might enjoy it. All right. Shall we jump in to our first question of the day? Let's do it. Who is kicking us off this morning?
Hi, Josh. It's Chloe from Manchester in the UK. I'm just curious that Kouri Richins has a financial trial, I guess, coming up. Do you think that they'll possibly settle that? Or do you think that has a possibility of still going ahead? Thank you.
Chloe, thank you so much for calling in from Manchester, England. Let's put you on the map. I should have said up front too. I forgot to say this, but we took last Sunday off for the holiday 4th of July weekend. Happy 250th USA. So because of that, we've got 2 weeks worth of calls. I tried to get to as many as I could. I know that there are some of you out there who are going to say, hey, where was my question? Please don't take it personally. Please don't get hurt. Call in again. But I tried to cover at least every topic that you guys were concerned with. So starting us off, Chloe is asking about Kouri Richins. Yeah, she's not over. It's not over for poor Kouri. And it's interesting, too, because her attorney was Kathy Nestor. Things didn't turn out all that well for Kouri. I wonder if Tyler Robinson was watching that or following it at all, and wondered if that might be a precursor for what he might go through. But entirely different cases, obviously. She's still got some financial crimes that she's got to worry about. Very similar situation to the Alec Murdaugh case when you think about it. Her financial situation was, according to the prosecution, much of the motive and reason behind why she committed the murder of her husband. But they didn't charge that along with the murder. And also, like Alec Murdaugh, they felt that his financial situation, the walls crumbling apart around him financially, was what caused him to murder his wife and son. But again, they couldn't charge the financial crimes along with it, but they brought it in to an extent so that the jury could understand it as a motive. So they did that to great success in Kouri Richins' case. They did it to great success in Alec Murdaugh's case. But on the second time around, I know I'm a little off topic here, but on the second time around for Alec Murdaugh, remember, the Supreme Court in South Carolina has said, by the way, pump the brakes on that financial crime stuff. They didn't say you can't bring it in altogether, but they said, while we're at it, while we are overturning this case, be careful, essentially, how you bring in the financial crimes. I thought they did it in a balanced way in Kouri Richins, and I actually agree with the court in South Carolina. It was a bit much in the Alec Murdaugh case. And the reason for that is you are allowed to bring in, this is prior bad acts. This is uncharged crimes. You are allowed to bring in uncharged crimes. When we say uncharged, we mean uncharged in the present case. So you're talking about financial crimes that she has been charged with, but they're not charged in the current case, the murder case. So it's considered an uncharged crime, prior bad acts, prior uncharged crimes. You can bring them in. And one of the big ways you can bring them in is if it's to establish motive. But you have to be careful because you don't want to turn it into a character trial, which is what they felt happened in the Alec Murdaugh case. And we'll see if that's one of the bases of appeal in the Kouri Richins case. But because of all that, she still has the financial crimes to face. In Alec Murdaugh's situation, he pled to those crimes. Kouri has not entered a plea. So Chloe's question is, do you think it will go the same way? Will they settle that case or will she go to trial on it? The answer is we don't know. She has not indicated, her team has not indicated, no one has said whether or not she's going to take a plea on that. So right now it's headed toward trial. But strategically, might she do it? Obviously, the bigger problem for Kouri is the murder case. The only reason why I think she might go to trial on the financial crimes case is she's in a different position in that right now she's got nothing to lose. In other words, here's how I'm thinking they might think this through. Let's say for some radical reason, she gets her murder trial overturned and gets a new trial like Alec Murdaugh, right? Why would she ever go ahead and plea to the financial crimes and then seal the deal that she's going to remain in prison, as did Alec Murdaugh? Remember, I know we're all upset that he's getting a new trial, but even if that trial is an acquittal, he's still looking at 40 years in prison on the financial crimes. So to me, she might be thinking, I'm going to take my chances here. Unless they're willing to offer me something so low that I can't pass it up, why would she want to give the prosecution a safety net without making them earn it? I guess is the best way of saying it. So to me, if you're Kouri Richins, you're thinking, I'm not giving anything away to them. I'm not going to give them that guaranteed prison time. I'm going to make them earn it. And if they earn it, fine. If they don't, great. Then maybe I get an appeal on my murder charge. This is the way, in my experience, most defendants think about things. It's just, even if the chances are incredibly low, you go with the chances. So great question, Chloe. Sorry that I kind of dragged that out probably longer than it needed to be, but I thought it was an interesting topic. And thank you for kicking us off from Manchester, England. All right, let's keep it rolling here. Where are we off to next? Well, first of all, let me thank Jules for the gift of memberships and kicking us off with the support today. I appreciate that. Always love the gifted memberships. Annalie Finch, best thing about Sunday, it's Sunday Funday. I agree with that as well. Thank you for your support. And Beth Ringel, thank you so much for the super sticker. You guys are fantastic. All right. Where am I at here? Okay, here we go.
Hi, Josh, Tiff, and the spectacular CC mods and members. This is Kim from Arlington, Texas, a center of the DFW Metroplex. I want to take this time to thank you, Josh, and your associates for having the best true crime court show on YouTube.
Aww.
I also want to thank Cody Thomas and Josh for doing the nightly shows on the Karmelo Anthony trial since it was closed to all of us. Cody did an amazing job.
He did.
And I thank him and you both for that. My question is, now that Karmelo has put together a defensive dream team, all pro bono, what are the chances of them getting this appeal passed? I really hope it's nil to none, but that's just my personal opinion. I would love to hear yours. Thank you, and thank your crew and Tiff, and again, Cody Thomas for doing a spectacular job, and even responding when I ask him a question on Instagram. Thank you all very much. Have a super, super Sunday fun day. Again, this is my first time calling, so if you don't get it on air, I understand because I'm really nervous and scared. Bye.
Kim, first-time caller from Arlington, Texas. Love the first-time callers. Thank you so much, Kim, for being part of the community and then also contributing to the community with the question. We appreciate that. Isn't Cody Thomas a rock star? Wasn't he fantastic? That guy, not only is he the nicest guy on the planet, but he also was just boundless energy and enthusiasm during that trial. And it was like you said, because there were no people inside the courtroom, it was so nice. And it was just his birthday. Oh, send him a note and some juice boxes. I didn't know that. Happy birthday, my friend, if you're watching this. Yeah, we didn't have cameras inside the courtroom, regretfully. So it was so nice to have somebody who was there talking us through it. And he did that after very long days, by the way. Another big thanks to him, because he would be in court all day. He works for Court TV. Then he'd be doing a bunch of coverage for them, and then he would end his night over at Courtroom Confidential. So we're grateful, and we're looking for the next excuse to have him back on the channel. What is he following now, I wonder? We got to figure out a way to get him back on the channel again. He was great. On the Karmelo Anthony case, when you're talking about, yeah, you said that they put together the dream team. Well, I don't care what kind of dream team you put together. If you don't have the facts in your favor, doesn't really matter, especially on appeal. On appeal, you're not talking about, does advocacy and trial savvy play a role, right? It's briefs. So yeah, put together a heck of a brief, and attorneys are very good at that. And that is definitely a skill set, but you're going to have the facts. So remember, whenever we're talking about an appeal, two things to keep in mind. One, an appeal is usually it is not based on the evidence. Okay. It's not a reassessment of guilt. You're not asking the appellate court to say, hey, they found him guilty. We'd like you to weigh in on that. That's not the question. The question is, was there something procedurally wrong? Was there evidence that was introduced that shouldn't have been? Was there evidence that was excluded that shouldn't have been? Was there something about the jury instructions that was unfair? Was there something that unfairly prejudiced the defendant that didn't give him a fair trial or fair opportunity? Not, hey, the jury said that he was guilty, but we don't think he's guilty and we want you to take a second look. The second thing to keep in mind is it's a very confined universe. It only has to do with what took place in court. So if there were discussions outside of the court or decisions made by attorneys that didn't make it onto the record, in other words, attorneys could have done, I know that there was a lot of discussion about ineffective assistance of counsel, which was another unfortunate side effect of not having cameras in courtroom. We couldn't assess how they were doing, but many people were saying they're not even putting on a defense. What are they doing? Are they going for an IAC here? Usually you see those creep up on appeal because it's kind of like a catch-all for appeals. But if they were having discussions with their client and making strategic decisions and not explaining those strategic decisions on the record, there's nothing to point towards. It has to be on the record. It has to be transcribed by the court reporter in court, or an exhibit admitted in court, or something marked. In fact, sometimes you will see in a trial that they might mark something as court's exhibit. You ever heard that? It's not an exhibit that they're necessarily publishing to the jury, but they're marking it as a court's exhibit. Why are they doing that? They're doing that to preserve it for appeal, because they know if they want to make these appellate issues later on down the line, there has to be something for the judge, the appellate court, to look at. You can't say, hey, Your Honor, we should have admitted this document, but we didn't, and we'd like you to take a look at it because we think it makes a big difference. No, they're going to say, no, that's not part of the universe of what we're considering. It's the four corners of the record, as it were. So if there's something in there, that might have some teeth, but I don't see anything in the decisions that the judge made, the evidence that was introduced, the evidence that was excluded, that stands out to me to say that there's a successful chance on appeal here. I think the jury got it right. I heard the evidence. I felt that they came back with the right verdict. And I also feel that they came back with the right sentence on this thing. I know that's a lot of time, 35 years. In California, you commit a murder, that's 25 years to life. You add a weapon allegation to that, that adds another 10, sometimes more. So it's kind of right in the wheelhouse of what you might have expected. It's just an awful case that you got this young man going off to prison for, you know, the better part of his life now, and another young man has lost his life, and their family will never heal from that. So thank you so much, Kim from Arlington, Texas, for asking the question. I hope that explains things for you. All right, let's keep it rolling here. Where are we off to next?
Hi, Josh and our CC crew. This is IGG Rocks in Utah. In the spirit of celebrating the 250th anniversary of our country earning freedom and all the blessings that have followed, I was thinking about how many of the founding fathers were lawyers. If you could choose one of them to meet face to face and pick their brain, which one would it be? And what would you want to know? Thanks so much for all you do, and lots of love to our CC crew.
IGG Rocks from Salt Lake City, Utah. Let's put you on the map. I hope you're staying cool out there. I was baking. It was really hot. I was out there. Utah has not been kind to Josh Ritter, I'll tell you that. Last few times I was out there, I was freezing my tail off, and then this time I was a puddle. But thank you so much, IGG Rocks, for asking the question. I'm kind of tap dancing a little bit here because I want to give you guys time to put in your answers. I thought this was a great question. We just had the 250th birthday of America, talking about the founding fathers. Which one stands out to you? Who would you like to have dinner with? Who would you like to ask a question of? And then as you were saying it, I realized you added one little wrinkle to it that I missed when I was thinking about it. You said that many of them were lawyers. Many of them were lawyers. But the person that I picked, I'm not even sure if he's a lawyer. I know a lot about him, but I picked Benjamin Franklin. This guy seems like he would have been a real character. Like, of all the founding fathers, who do you want to go grab a beer with, right? Adams, great one. I saw Thomas Jefferson, also incredible. I'm picking Ben, right? Don't you think he would have been a good time? I feel like if you had gone out for drinks with Ben, you definitely would have gone to bed before him, right? You would have been, all right, buddy, we got a big day, of diplomacy with the French tomorrow. I'm going to get a good night's sleep. You take care. And he would have been still hanging out with the band at the pub, at the public house. He wasn't a lawyer. So there you go. Here's some interesting little factoids about Ben Franklin, though. First of all, he wasn't a president. Little trivia thing. He's on the $100 bill, but he's never was a president. He was apparently excellent chess player. He is credited for organizing and creating the first volunteer fire department in America. The guy was a real Renaissance man, just involved in everything: science, politics, diplomacy. He spoke 5 languages fluently. He was a big part of what allowed for the colonies to stand up against the entire British Empire because of his diplomacy. But he was also a little bit of a kooky guy too. He wrote, we all are familiar with Richard's Almanac, which is incredible. If you haven't ever read it, it's not like a book, but it's like just got a bunch of fantastic kind of words of wisdom in it. We all know his experiments with electricity. If you ask any grade school kid, they're going to talk about the kite with the key and, electricity. Did you know that he also tried to kill a turkey with electricity? And he also cooked a turkey with electricity and nearly killed himself doing so. He was just a wild guy. But my favorite of all was, and this is probably what I would ask him about. He liked to take air baths. What is an air bath, you might ask yourself? Well, this is where Ben would stand fully naked as the Lord created him in front of an open window at his house for a couple of hours at a time. So first of all, you got to imagine the response of his neighbors to all of that. But he viewed it as just kind of allowing the elements themselves to cleanse him. And he would stand there naked. I don't know what he was doing, reading, doing whatever he needed to do, just getting himself an air bath. Maybe he was far ahead of his time and into water conservation as well. So who knows? Ben Franklin is my choice. I saw a lot of great suggestions from all of you. That was a fun one. Thank you so much, IGG Rocks, for asking that. Salt Lake City, Utah. Thank you. All right, let's keep it rolling here. Oops. And thank you, Wendy Joan, for gifting the memberships. So very kind of you guys. And Deb, thank you so much for supporting the mods with coffees. Appreciate that. All right. Where am I at? Here we go.
Hello, Courtroom Confidential folks. This is Ashley, longtime listener, first-time caller. I don't get to listen live, so I listen to replays. I'm in Linwood, Washington, but as we're close to Seattle, we call it Linwood, Washington. Question, D4vd, Reiner. I know there was a question a couple weeks ago about if there would be racial tensions should D4vd get the death penalty and Reiner not. My question is, what's the point of the death penalty or even going for it in California? We know that California is never going to do it. Most of the time, they just make it life in prison, right? They don't put anybody to death. So as going for the death penalty costs so much more, takes more time, opens up appeals, all that good stuff, why even bother? Is it just to play chicken and see if you can get them to plea to take it off the table? And why would they plea to take it off the table when they know in all likelihood he's going to die of old age before he ever gets a death penalty? Anyway, I have other questions, but I'll go back with those. Love your shows. Love the weekly wrap. Love all of your confidentials. You should do more. If I had more to listen to, I'd be happier. Take care, everybody. Thanks for all you do. Bye, folks.
Ashley from first-time caller, Ashley from Linwood, Washington. Thank you so much for the kind words. Thank you so much for being a part of our community and now joining in the conversation. Ashley, I love what you said about do more. I don't think I could. Somewhere in there, I got to sneak a snack and a nap. So I'm doing as much as I can, but I appreciate that you enjoy our content. Talking about, I like how you said D4vd. I don't know how we're pronouncing this. I pronounce it David. I've heard many people say D4vd. I'm going with David. And I'll tell you what, now that you are charged with capital murder, I'm going by your name because you're no longer a child and a internet music sensation. You're David Burke, in my view. David Burke is charged with the murder of Celeste Rivas Hernandez. And that's, I think, the way that we should talk about it. I'm not trying to chastise anybody. We're obviously going to put D4vd on a lot of our titles because people just recognize that and it's become shorthand for this horrific case. But you bring up a very good question that, listen, gets debated quite a bit amongst prosecutors, by the way, too. In California, the death penalty is on the books. Okay. There have been more than one. In fact, the last one was not all that long ago, within the last 5 years or so. Many, many attempts to amend the California Constitution to remove the death penalty entirely. Every single one of those have failed. Rather resoundingly, the voters of the state of California want the death penalty on the books. Now, each county has its own elected district attorney who can choose when to pursue the death penalty and when not. The last DA before the current one, George Gascon here in Los Angeles, George Gascon, refused under no circumstances to pursue the death penalty. And that was what he ran upon. And the voters of LA voted for that. They had a change of heart. I'm very pleased to say and happy that they did. Not just based on the death penalty, but just based on public safety, elected a new DA, Nathan Hochman, who has said, no, we're not taking the death penalty off the table entirely. We're going to do it on a very conscientious case-by-case basis based upon many different factors. I was in the DA's office for, you hear me talk about it. I was there for over 10 years as a prosecutor for much of that time, but also as a law clerk for years while I was in law school and after. So I have a lot of experience seeing when the DA's office, during the time I was there at least, pursued the death penalty and when they did it. And I will say, I never saw an instance where I thought it was being pursued inappropriately. Like this person didn't deserve it and they're going after somebody overly aggressively. In fact, I think most times you could say that there were cases that probably deserved the death penalty that they didn't pursue it for whatever reason. There's an entire committee that meets. This isn't just kind of willy-nilly stuff. But to your question, right now, the governor, Gavin Newsom, has completely of his own accord removed the death penalty from, I'm trying to think of a better word, but the only word that comes to mind is execution. He essentially, there are people on death row. There are people who have received the death penalty as a punishment. That is their verdict. A jury has decided, and that is their verdict. And he's essentially saying, I'm shuttering the entire thing. Listen, I'm not trying to get into the politics of how you may feel about the death penalty. I know a lot of people feel strongly about it for ethical, religious reasons, whatever it may be. But I just think that as a politician, if the people have spoken, it's kind of in the job description to go by what the people have said. And if the people have voted to keep it on the books, why one man takes it upon himself to say, we're just not doing that is kind of beyond me. But here's a couple of answers to your question, Ashley. One, there could be a new governor. There's going to be a new governor, in fact, pretty soon here. That governor could say, yeah, I'm undoing that process. We're going to go ahead and reinstitute executions if we feel that if there is a verdict. I think that's probably highly unlikely, but it could be. The other thing that you bring up that's interesting is the death penalty, though it never should be, and prosecutors never use it that way, can also be a tool, right? We saw in Brian Koberger is probably the best example. People want to avoid the death penalty, and so they will cooperate sometimes and take a plea and give over information if it means that the death penalty will be removed from consideration. Now you say, well, why would they ever do that when California is never going to execute someone again? Don't they know that? The answer is, it would be interesting to understand the psychology of somebody looking at the potential of a death penalty. I will say the most hardened of criminals, you tell them it's not going to ever happen, they don't really care. There's something about the psychology of living in custody, realizing that there is the potential that the state could take your life, that still does motivate a lot of people to cooperate. And so it is still a tool. Even in the state of California, I have heard recently of cases where people want to avoid the potential of the death penalty and will take a plea. Will that happen here with David? I don't know. With Nick Reiner, they haven't made the decision. My prediction to all of you is that they will not pursue the death penalty against Nick Reiner, not because the crime isn't horrific, but because of his mental health issues. It's just very difficult to convince a jury of that. With David, though, they might. It's a horrific case. The only thing he's got going for him is he doesn't really have a criminal record. But I'm telling you, you first of all begin the systematic abuse of a young woman, and then you kill her when she says she's going to tell people about it. That's about as bad as it gets in my book. So great question, Ashley. I hope that kind of answers it. There's no real, answer. But I hope that kind of answers things for you as far as what is going into the thinking of pursuing it or not here in California. All right, let's keep it rolling here. Where are we off to next?
Good day, Josh and all the CC crew. I'm phoning from Pretoria in South Africa. Very nice to be sending my first time question in. I'm currently watching a case with the Grizzlies, and this question just came up. Does lawyers, when they select an expert witness, go and actually check what and how they previously testified on other cases, and does that influence them? Then question 2, on the same scenario, can the other side then also do that and go and dig for adverse discriminating evidence of a witness? I know there was a previous case, can't remember who, where the witness said he had a degree on his LinkedIn profile, which he actually did not have. So, and how ethical is this? They have to suss out the witnesses, so it does make sense. But yeah, this is kind of interesting. Thank you very much. Yolanda, I'm phoning from Pretoria in South Africa. Have a lovely day further.
You too, Alonza. Thank you so much for calling in. Alonza from Pretoria, South Africa, another first-time caller. That is our third first-time caller of the day. I got to give you guys more time off, I think. When I give you a couple of weeks off, everybody works up the courage to call in. I appreciate it. Thank you so much, Alonza. And I cannot begin to answer this question without first acknowledging that you said that you are a Grizzly, a follower of Grizzly True Crime. Congratulations to my good friend, Gisela. They hit 500,000 subscribers over on her channel. Isn't that incredible? That is just so fantastic to me. And it also seems like so far away. Like we're trying so hard here, and we're so pleased with the growth that we've had. And she is at 500,000 subscribers and deserves every single one of those people. Every single one of those people who subscribe to her channel, I'm sure, are completely grateful that they found her channel. So if there are, I see all the teddy bears in the chat. If there are people here who don't know about Gisela and Grizzly True Crime yet, do yourself an enormous favor and add yourself to that group of 500,000 people. Because she does some incredible work. And sometimes she's listening on a Sunday when she's out on a jog. Maybe she'll be listening later. Greetings from sunny Bermuda. Kathy down at Gossip Rumor and Innuendo, another one of my favorite channels. Well, I hope either you're there on an investigation or you're there for fun. Either way, I hope you're having a good time. Congrats to Gisela. Yes. All right. And a great question, Alonza. I know her audio was going in and out a little bit, so I'll try to summarize what she was asking. She's saying that they were watching on Grizzly True Crime a case where an expert was testifying, and the question came up. These experts testify in many cases. Can their prior testimony be used in their current case? Can it be used to impeach them? Can it be used to engage them, I guess, in their current testimony? The answer is Absolutely. In fact, when I was in the DA's office back in the caveman days, we had files on many of the experts. There are many experts who make the rounds, as it were, especially in types of expertise that you see fairly common. When it comes down to kind of crime scene analysis, there's like the guys that you're always going to see. Dr. Werner was one that was big. Dr. Lee was another big one you would see all the time. These medical examiners who would testify on the behalf of the defense. Another big one was eyewitness identification. We had a lot of people. There was a Dr. Loftus who would testify, and I'm forgetting some of the other names. But we had databases, and then you would just talk to your fellow prosecutors too. Send out an email blast. I've got Dr. Loftus on an ID case coming up. She's going to make some sort of argument about weapons focus. So weapons focus is that if a person IDs a suspect and a gun or a weapon is involved, there's this theory that the person's paying so much attention to the gun that they can't really identify the person's face. And so that is something that they'll come in to testify to. And you'll get transcripts of prior times that these people testified, and it's very valuable. You could go through it and find instances where they made some statement and try to cross-examine them with that. Lots of information on these people. In fact, part of our databases included kind of cross-examination scripts that people had put together, which I also found to be very helpful when you're in a pinch. So yes, the answer is yeah, it's all fair game. If somebody, it's all prior inconsistent statements that were given under oath. So sure, somebody's on the stand and they're testifying that, hey, IDs, the biggest problem with making an in-person ID is cross-racial identification or something like that. And then they're testifying in the new trial and they're saying the biggest problem in in-person identifications is weapons focus. That's a small but significant difference. And you can go back. Well, didn't you testify in the case of People versus Ritter, where you said that no, in fact, it was X, Y, and Z, and now you're saying it's Z, Y, and X? And yes, that's prior inconsistent statements. They've made those under oath. Even if they hadn't made them under oath, it's prior inconsistent statements that you can impeach them with. So yeah, these experts, especially the ones who are kind of more prolific and testify quite a bit, get caught up quite a bit and have to be careful that they're consistent. Well, that wouldn't be a problem if you're just telling the truth, is my answer to those folks. So you can tell that I've got a little bit of a, what's the word I'm looking for? A little thorn in my side or grinding of my gears when it comes to experts sometimes, because I will tell you, you can find an expert to nearly say anything you want to say. I mean, if you got enough money and you're willing to search far enough, believe me, you can put somebody on the stand who's got a CV that can say nearly anything you want them to say. Tread lightly when you put some trust in expert testimony from people. Just my cautionary advice of the day. Free advice of the day. All right. But thank you so much, Alonza from Pretoria, for being a first-time caller. Beautiful Messy Ball says, D4vd, I think sort of mocks it. I'm just going to say Defendant Burke. How about that? Therapist, thank you so much for the super sticker. That's very kind of you. And Ann Strauss, thank you for the super sticker. Please allow me to wish a very happy, this is from Tom Taz, 46th wedding anniversary to my wife, Kathy. You are truly the best thing that ever happened to me. Aw, Tom, how sweet of you. Absolutely. Happy 46th wedding anniversary, Kathy and Tom. That's very cool. Oh, that made me happy. All right, where are we off to here?
This is Denise Ramirez, and I live in Chickasha, Oklahoma. I have a couple of questions. My first one is I was under the impression that Judge Graf on the Tyler Robinson case is a brand new judge. And I was wondering why they did not put a judge on there that maybe had been around for a while, had had some more experience under his robe, as it were. Um, and my second question is on the Blaise Taylor trial. I noticed that the judge was pretty testy and abrupt and disrespectful. That's just my opinion. I do believe that Blaise Taylor should be in prison, but I was wanting to know if you thought that maybe that might affect his appeals in the future, if that could bring it back to court because of his behavior. Thanks so much. And I love your show. I respect you totally. I think you're really good with the people, and I appreciate you. So we'll talk to you later. Thanks a lot.
Oh, Denise, that's so very nice of you. Denise from Chickasha, Oklahoma. I always thought it was pronounced Chickasha. So thank you for correcting me on that. Let's put you on the map. Great question, too. Talking about a couple of different judges here. We get a lot of questions about judges. People are curious about that. First of all, you've got Judge Tony Graf. We just saw him in action over the course of the last week on the Tyler Robinson case for the murder of Charlie Kirk. Receiving a lot of criticism from myself as well. And I'm trying to be a little more gracious about that. He's got an incredibly difficult job. It is by far the biggest case taking place as far as media attention in Utah right now. Probably will be one of the biggest cases in Utah for a very long time. And I know that I'm saying that with cases like Kouri Richins taking place in the same state, but the media attention that has fallen on this case is really a spectacle. I mean, there was just the entire parking lot was filled up with different networks setting up to just do coverage of this case over the last week. So he's under the microscope, right? He's under the incredible amount of public attention and criticism. And I think where I want to give him more credit is I think that he is very earnest and trying to do the right thing. And he's very thoughtful. He's certainly not flippant. He's certainly not rash. And he's very respectful and trying to do the right thing. One of the criticisms, though, is that it's taking a long time and that he seems to be giving a lot of breathing room to the defense to make objections and arguments that many people, myself included, feel like they shouldn't be given that kind of luxury. And when criticizing him, people point to the fact that he's a very new judge. He is a judge that I think was appointed to the bench within weeks, just weeks before Charlie Kirk was murdered. So this is like the first big case he ever got assigned, and it is a whopper of a case. So Denise says, why? Why was he assigned this? Listen, every jurisdiction does things differently. And apparently in Utah, what I've been told on this is that it's just kind of a take your ticket at the butcher stand sort of situation out there. Calling number 42, and his number came up, and he was next in line to receive a case, and that case just happened to be the biggest case in the entire state. Listen, I'm learning a lot about Utah and the way that they practice out there, and I have some notes, some notes for all of them. I think one of the things they should probably rethink is this. In where I'm used to practicing, there is one floor in particular here in LA County of the criminal court building. There's many branches and different courthouses in LA County, but the main one downtown is called the criminal court building. And on one floor, the 9th floor, you may have heard this referred to in the past, is where they handle all the long cause, high profile cases. OJ was handled there. Danny Masterson most recently. Not Menendez. The Night Stalker. What's his name? I'm blanking on it right here. Ramirez was handled there. All the big cases on one floor. Okay. Weinstein was handled there. All the big cases you can think of. Phil Spector was handled there. Are all handled on one floor. Why is that? Because they put the most experienced judges who've been on the bench for decades and have exemplified themselves as being able to handle high profile and complex cases on that same floor. So they usually send it to somebody on that floor. And in many cases, the head presiding judge might decide even what judge on that floor should get something. If it's a particularly high profile or difficult case, it might be steered in the direction of the far more experienced judge even on that floor. So poor Tony here got it kind of the short stick in many ways. And I think he's doing the best job that he can. I hope that he changes the way that he's doing it. I will say this. I feel like all of the decisions he's made have been right. He just takes far too long to get there. So we're just going to have to deal with that. Blaise Taylor, though, talking about the judge in that case, whose name I'm blanking on right now, and I apologize for that, received a lot of criticism from all of you because of his demeanor. A lot of people felt that he was very short-tempered with the defense in particular, that he interjected himself in the case, that he was asking witnesses, lodging his own objections. Here's the thing, Dozier. Is that his name? Dozier, yes. Here's the thing. None of that's illegal. The judge is allowed to do it. You just kind of hope that they don't for the most part. I've had judges before who I really liked that just had a reputation for asking their own questions. I remember one judge in particular, you get done with your examination of a witness and you're like, that was chef's kiss. I had that witness exactly where I wanted him. And then the judge would go, I got a couple of questions. And you're like, oh God, here's where the wheels come off. They're allowed to do it. They're allowed to, they are allowed to lodge their own objections if they feel that the evidence is irrelevant, calls for hearsay, whatever it is. They are the arbitrators. They are the referees of the courtroom, and they're allowed to make the calls if they want to. Some judges don't. Some judges say, listen, I'm allowing you guys to handle this case how you want. And if you strategically don't want to object to some stuff, I'm not going to object on your behalf. And then some judges just have a bigger, more mild and temperament than others. And I've been in the wide spectrum on that as well. I've had judges who have just been up my tail from the moment I stepped into the courtroom to other ones who are like, best friends of mine now after we've done a trial together, literally. So nothing about this judge's behavior, again, coming back to that idea that we talked about with appeals, was there something on the record? Will the transcripts themselves reflect some sort of inappropriate behavior by the judge? And much of the judge's demeanor is not reflected in the record unless the defense attorney stands up and says, Your Honor, you have overruled my objection, and you've also been very rude about it in front of the jury. Unless that's on the record, the appellate court has nothing to consider. And I'll tell you, even if they put that on the record, what is the basis for appeal? Maybe you could make some argument that if the judge was being very biased in their demeanor towards one side over the other in front of the jury, perhaps you could mount an argument off of that. Perhaps you could say that somehow that judge was tilting the scales of justice towards one side over the other by the way that they conducted themselves in front of the jury. But I'll tell you this too. Good luck with that. They just got themselves a real meanie of a judge. Kind of not much to do about it, but give us something to talk about. So thank you, Denise from Chickasha, Oklahoma, for calling in. I appreciate that. All right. Let's keep it rolling here. Not my fault. Not my fault, Kaylin.
Hi, Josh. Hi, CC crew. This is Mariana from Budapest, Hungary. I'm a long-time listener, first-time caller. So I was watching the cases you discussed recently, but from other channels as well. And I noticed that there are more and more cases that are seemingly overcharged. I mean, there were cases in the past as well. I mean, most famously, I can remember is Casey Anthony. And sadly, we all know how that ended. So I was wondering, what are the rules when it comes to adding a lesser included charge? I know you cannot simply add the bunch and see which one sticks, but it seems really different between the cases and between the different states. Sometimes even the judge offers to add the lesser included option right before deliberation. I believe in the Pino case, the defense refused to accept lesser included, and they just went for the guilty or not guilty option only. So how does this work? This whole setup seems a bit chaotic to me. Do you think there should be a revision to the current system? Looking forward to your answer, and I'm only about 80% juiced after this terrible heat wave. Okay, bye.
Mariana from Budapest, Hungary. Let's put you on the map. Wait a second here. Zoom in there. Do we have one more person from Hungary that has called in before? Wow. Look at us hitting the charts in Hungary. I love it. All right, Mariana, I put it upon you to find your other CC friend there in Hungary and start the local fan club. Appreciate you calling in. And by the way, another first-time caller. If you're keeping score at home, what does that make it? 4 today? Yeah. Good job, everybody. I love it. Are we just going to go every other week now? Is that what we're finding out? Is that the hint that we're being given? No, I couldn't do that to you yet. We'll see how exhausted I get. All right, Mariana. Great question, too. What are the rules when it comes to adding a lesser included charge? And you're right. It is a little chaotic because it is different from jurisdiction to jurisdiction. You bring up the George Pino case, and I'm glad that you did. That's an excellent example. That was out of Florida. Excellent example of one way that it can be handled, which is it's kind of up to the parties to agree upon it. So here's the ways it can be done. One, it can be left entirely to the discretion of the prosecution. If the prosecutor wants to charge murder, first degree, and that alone, some jurisdictions say, you guys want to go for broke? You're going for broke. If they can't find first degree, but they still feel it might have been a murder of a lesser degree, and you don't put that on the table, they're coming back with an NG on first degree, and you're just going to have to live with that. Other jurisdictions handle it upon request. So if either side says, Your Honor, we feel that a lesser included of second degree murder should be added here, the judge will take a look at the facts and decide whether or not the facts support that type of a finding and go, okay, I'm going to go ahead and add that. Now, that's an important point, though. The judge has to decide, do the facts support it? In other words, if you're charged with first degree murder and you go, Your Honor, I also want involuntary manslaughter on the table, the judge can take a look at it and go, the allegations are here that they put a gun to the back of a person's head and pulled the trigger. There's no elements of involuntary manslaughter here. I'm not just going to add it. The judge has to decide, is there a supporting factual basis for this? As well as the judge does the other way, right? We've all seen those situations where the defense will make an argument after the presentation of the prosecution's case. And if the judge feels there's not a factual basis to support the charge that they're charged with, the current count, the judge can dismiss it then and there or reduce it then and there. It's very rare, but we have seen it before. And then there's kind of this third category of what we call a sua sponte duty. Aren't you happy that we got to use a little Latin on a Sunday? Lawyers love to use Latin because then it explains why you need to pay us to do the job. Well, you don't know the Latin. I know the Latin. Sua sponte duty means that the judge essentially takes it upon themselves to add a count. if the judge, even without the request of the parties, feels that the evidence supports a lesser included charge, the judge will add that themselves. And sometimes you see that. In California, that is the way that it works. The judge has a duty to that, by the way, not just if the judge is so inclined, but if the judge feels that there is a supporting evidence for a lesser included, they have an affirmative duty. They must instruct on that lesser included. I actually think that's probably the best way to handle it. If the facts are supporting a crime and there's a reasonable way where the jury could find the person guilty of that crime and not the crime charged, isn't that the pursuit of justice to go ahead and put that potential crime in front of the jury? I think that's the right way of doing it. But to directly answer your question, Mariana, it's different in every jurisdiction. And some jurisdictions allow for this kind of strategic risk-taking where it's all or nothing. Others allow for charges to be added. You will see some instances where they might add the entire spectrum. They might add first degree, second degree, manslaughter, involuntary manslaughter, because they feel like, hey, I want to get everything in front of the jury just in case. Great question. I hope that clears it up. And thank you so much for being a first-time caller from Budapest, Hungary. I love that. Arizona gal, thank you so much. Says, hi, Josh and CC fam. Driving home from Phoenix with the family listening to Sunday Funday. In the car? I love that. We're mobile. Love your channel, and thank you all for all you do. I look forward to it every week. That's very sweet of you. And please keep your hands at 10 and 2, eyes on the road, check the corners, and make sure to stop for snacks. Therapist, thank you so much for the super sticker. Says, any thoughts on Nolan Wells' death July 4th in Mississippi? I am sorry, therapist. I do know this name. I don't know about this case. I've just been so underwater with the Tyler Robinson stuff. We took off right after the 4th, and I hit the ground there in Provo, and I've just kind of been buried with all of that. And I'm trying to keep come out for air after this last week. I will look into this one, but thank you so much for asking the question. And Race and Rodeo, thank you for gifting the membership. That's very, very kind of you. Can we hit 600 likes for gifted? I think we can. How many do we have right now? 400? Boy, you'd like to really pump those numbers, huh? You don't make it easy. 600. All right. Comes from the boss. If you all can get there, we'll gift out some memberships. All right, let's keep it rolling here.
Hi, Josh. Hi, Tiff. Hi, Caitlin. Hi, Mods. Hi, chat. It's Little Miss Red Velvet from Manchester. I'm really busy at the moment, so I'm not managing to get into many lives. So I hope you're all okay. This week, I wanted to ask about immunity deals, Josh, if you could explain a bit about those, the full immunity, what that entails, and also partial immunity like Wendy Adelson got. Who gives it? What are the parameters involved in immunity deals? And how are they formatted? And how long do they last? And can they be revoked? Just thinking about it with regards to the Nancy Guthrie case, if somebody that was involved came forward, how would they go about that, and how would whoever's giving the deal format it? Look forward to seeing you on Sunday Funday. Should be there. Take care. Bye.
LMRV, are you here? Are you busy? Well, if you're here, hello, my friend. From Manchester, England, let's put you on the map. Immunity. I love this question. We get this every so often. People want to know about immunity and how it works. Let me start off by saying grants of immunity are incredibly rare, and they are usually not something that the witness testifying under immunity wants. Okay? It's not like a gift to these people. I think is kind of important to understand. These are usually people who don't want anything to do with the trial. They're like, I don't want to be anywhere near a courtroom on this. Where they're used is when you're trying to compel a person to testify, and that person might otherwise enjoy a Fifth Amendment protection. So let's use the recent case of Tyler Robinson. His roommate, romantic partner, Lance Twiggs, testified. Gave an interview under a grant of immunity that was then played in court. So Lance Twiggs wasn't physically in court, but Lance Twiggs testified through this recorded statement that was under a grant of immunity. And I feel like whenever we hear immunity, sometimes people go, well, that's not fair. Why are they letting this person off the hook? They're not, okay? Lance Twiggs has valuable information. Lance Twiggs also provides the foundation for a lot of valuable evidence in this case. Lance Twiggs establishes the foundation for the text messages between him and Tyler Robinson, the foundation for the Discord chat that Tyler Robinson had online, the foundation for the letter handwritten by Tyler Robinson that was recovered from the home. And he had a personal conversation with Tyler Robinson where he admits to his involvement, to the murder of Charlie Kirk. That's 4 times now, if you're counting, that Tyler Robinson has admitted he committed this murder in some form or another. And all of those can be established through Lance Twiggs. So he's very, very important. But he kind of knows a lot of stuff that maybe he should have done something about. And he's very close to this crime. So after this murder takes place, he lawyers up. I am sure that investigators say, we want to speak to this guy. And his lawyers say, he ain't saying nothing. He's got a Fifth Amendment protection. He could be criminally implicated in all of this. He is going to plead the Fifth. And they say, great, we're going to give him use immunity and compel him to speak. Now, I'm sure an agreement was worked out because I'm sure the conversation became much more like, listen, it is right now the state of Utah versus Tyler Robinson. If you want it to remain that way, and instead of being the state of Utah versus Tyler Robinson and Lance Twiggs, we suggest that you take this grant of immunity and speak to us. And I imagine they said, yeah, that sounds like a good deal to us. But there are 2 different types of immunities. Most of it, the vast majority of the time, is what's called use immunity. You may have heard it called derivative use immunity or derivative immunity. All that means is you cannot use what's coming out of my mouth against me. You're asking me to speak to you. You're compelling me to speak to you. I'm doing that because you're saying they're not going to prosecute me for what I tell you. But that doesn't mean you can't prosecute me. If you independently find out some other way of connecting me to this crime, let's say, and this is not at all in existence, I'm just trying to create a hypothetical. Let's say that we find out later on that Lance Twiggs had, provided a map of the campus to Tyler Robinson, or they had extensive conversations about how Charlie Kirk, I said Tyler Robinson, I mean Charlie Kirk, needed to go. That they could use that. If they find that independently and they decide they want to charge him, they could go ahead and do that. But they can't use where he's saying, I had this conversation with him, or the things that he told them. They can't use that unless they have an independent source. So kind of an important thing to understand about all of this. It doesn't mean that that person is off the hook entirely. And if they're lying during the course of this interview, this is, very, very similar to a proffer interview. If they're lying during the course of this, all bets are off. They can use it against that person. They lied. The other type of immunity is what's called transactional or umbrella blanket immunity. And that means a complete bar from everything. That means that you are, for whatever reason, so incredibly powerful to the prosecution that we're not going to prosecute you for the current offense or any related offense ever. Where do you see this? Well, you never see it, but the rare instances you see it is like in a mob case, right? You've got a guy who's willing to turn state's evidence, and he's going to go into the witness protection program, and he's going to tell you about every mob hit that he was involved in, everybody who called the shot, how they were racketeering their funds, all of that under a complete grant of immunity. Very rare, almost unheard of, but those are the types of situations you might see it. And the other reason why it's kind of rare is not only is it's because it's only in these unique situations where they need that information and have no other way to get it, but those witnesses are difficult to put on the stand. Lance Twiggs was, I thought, an excellent witness from what we saw in that recorded interview. But you can guarantee that the second he takes the stand, the first line of questioning from the defense is, you were granted immunity in this case, were you not? You were granted immunity that anything you said cannot be used against you. Isn't that true? And that starts to cut away at the veracity of that person's testimony. So hope that explains things. Little Miss Red Velvet from Manchester, England. Always love hearing from you, my friend. All right. Yeah, you did call in. You did. She's, the poor thing. She's having memory loss. Yes, you did call in. All right. Here we go. That's cute. That makes me laugh.
Hi, Josh. My name is Star Birch, and I live in Fort Dodge, Iowa. I don't think Fort Dodge is on your map yet, so maybe I'll be the first. Anyway, the reason why I'm calling is that I happened to see a small news article about Mark Sanchez and that there was many delays for his trial. I haven't really heard much about him up until now. I did hear in this clip that I saw that the trial was supposed to start July 8th. Anyway, is there any other information you might know about this trial and what's going to go on? I would really like to know. Thank you so much for taking my call, and I love your show and look forward to seeing it each week. Thanks. Bye-bye.
Star from Fort Dodge, Iowa. Another first-time caller. This is incredible. I loved it. Wow. Way out there in the middle. Could you zoom out a second? We got to get some folks around you there, Star. Fort Dodge, Iowa. Great question. Mark Sanchez. Yeah, we haven't thought about this one in a while. I kind of forgot about it, right? Because it's taking forever. Mark Sanchez, starting quarterback, star quarterback of USC football, goes on to the Jets, a couple of other teams, I think. Then he's a broadcaster for Fox Sports. And then he's in Indiana and he gets blotto one night and gets into it with this poor truck driver, 69-year-old Perry Toll. This took place in October of last year. Look at this guy. You ever think you're going to have an issue with a guy like that? Well, he does. And it's just bizarre. And then it's also violent. So he gets into it with he tries to pull the guy out of his truck, and then he tries to get into the guy's truck. And Perry pepper sprays him or something, right? Am I missing this? Perry, no, a knife. Perry's got a knife to defend himself because Mark Sanchez is a big dude. Mark Sanchez is going after him, and Perry has to end up stabbing him, I think, to keep him off of him. And Perry ends up in a hospital. Mark Sanchez ends up in the hospital, and Mark Sanchez also ends up in handcuffs because he's charged with felony batter resulting in serious bodily injury. Also some misdemeanor charges for battery, public intoxication, unauthorized entry of a vehicle. Bad news. Ruined his entire career. I don't know if this guy will ever recover from this. Maybe after this is all said and done, he'll, go on some PR campaign and shyly sneak his way onto another football broadcast or something like that. But there's a lot of folks out there who would have wanted that job. And, you know, they're not out beating up poor little dudes on the poor little delivery men. He used the pepper spray before the knife. So I was right. Both of them. Poor guy. What's the latest? The latest is the trial was continued again for the 5th time. It was set to begin tomorrow, July 13th. It's now been pushed back to September 8th. I don't know why. Well, I have my guesses. Is that his attorneys are working night and day to try to get some sort of plea deal out of this that ends up not giving him any jail time, something that he can kind of pay a bunch of fines and fees and do some apology campaign and get out of the whole mess and not end up with a felony. I imagine the DA is like, you put a guy in the hospital. How is this not a felony? I'll be quite honest with you. How is this not jail time? You put a guy in the hospital. Like, what are we talking about here? But he's this big time celebrity and he's got some high priced attorneys. And I'm sure they're doing their best to just kind of wear the DA's office down. That would be my guess as to why it's taking so long. The last I heard on this too is that they have 50 different surveillance videos on top of cell phone videos. So maybe combined between surveillance and video. They got a lot. Apparently this whole thing was captured on some sort of video. So not looking all that great for Mark. We'll continue to follow that one though. I think that one will be interesting. I don't know if it'll head to trial, but we'll continue to follow it. All right. Thank you so much, Therapist for the kind donation of a membership to somebody out there. Whoever receives that, I hope you enjoyed it. Court Dog Daniel's in the house. He says, thank you supporting the mods for coffees. Thank you, Court Dog Daniel. And, oh, yes, this is an ad-free live. We have dedicated ourselves here at Courtroom Confidential headquarters to always going live without interruptions from YouTube. So it's your support that helps us do that. So thank you to everybody who's helping us out today. All right. Where am I at here? Here we go.
Hi, Josh. First time caller here from Ohio. I wanted to ask you about preliminary hearings. I'm watching the Tyler Robinson preliminary hearing now. I'm from Ohio, and normally we do grand jury indictments here. I very rarely see anyone do a preliminary hearing. I don't know if this is a state by state thing. I've noticed when they do a preliminary hearing, the cases seem to draw way out. The defense just keeps stalling with Nick Reiner, Tyler Robinson, and then the David case. They're all kind of in the same boat. So I wanted to ask you, why don't they just do a grand jury indictment to kind of get the process started and speeding along? I guess maybe it is a state by state thing. Is there advantages to doing a preliminary for the prosecution? I feel like there's not. I just feel like a grand jury indictment is a lot quicker. The Monique and Spencer Tepe case is local to me, and they did a grand jury indictment on that. So anyway, thank you. Love your show.
Yeah, the Tepe case, that's another one that's kind of dragging along. We've been following that closely, and then it just seems to have kind of gone off the radar. Hey, annoying me is here. Not at all. Courtney, thank you so much for asking the question. Courtney from Ohio, putting you on the map. First time caller again. Are you counting? I think that's 6. We have to have set a record. What do we get for that? Boss lady, do we get anything for 6 first time callers? She's like, okay, yeah, you get a little something. Thank you, Courtney, for following. Thank you for being a part of the community, and thank you for jumping in the conversation. And a great question. Why don't they just do a grand jury for Tyler Robinson? Why did we have to sit through 5 days of this grueling, laborious prelim when they could have just put it in front of a grand jury. Problem is, in Utah, they can't put it in front of a grand jury because they don't have a grand jury in Utah. I think this case is probably the biggest advertisement for instituting the grand jury system in Utah that they may have ever seen. I was not even aware of that some jurisdictions don't have a grand jury. I don't know if that's something that they have to get some sort of constitutional amendment. Probably is. I don't know if it's a law that simply can be passed. This is all kind of my pay grade. I'm just a lawyer, but somewhere somebody's going to have to figure it out there in Utah and get that on the books and get the grand jury system in place, especially for cases with this kind of complexity and media attention, high profile cases like this. This would have easily been an indictment that happened months ago. Months. We would have been past indictment, I imagine, within the first month. But they don't have one there. So get it together, Utah. My second home is now becoming Utah. I think I'm going to file my taxes in Utah. I think I somehow qualify by the amount of time I've been there this year. But great question, Courtney, and we appreciate you calling in and for being a first-time caller. All right. Where are we off to next?
Hey, Josh. It's me, Haley Orozco. I was watching your day 3 recap of the Tyler Robinson case, and you said how there's no grand jury in Utah, but there is a jury. What's the difference between a grand jury and a jury? I'd really like to know because I'm still learning all this stuff, and you are great. I appreciate all that you do. Thank you so much. Again, I'm still a new listener, but you're awesome. Thank you.
Thank you, Haley. Oh, Haley, I appreciate you calling in, but you didn't tell us where you're from. Haley from no location. Oh, it kills me. If you're listening right now, Haley, let us know where you're from, and we'll try to figure out how to tag you on the map. But see, apparently what I told you a few days ago, I'm still saying today. Consistency here at Courtroom Confidential. That is true. That was from day 3. But this gives me a good opportunity to say, if you guys didn't get a chance to watch the Tyler Robinson prelim, or you're still curious as to how certain things ended up, we did a recap every day for the last 5 days of that pretrial, Monday through Friday. Please check it out. It's up on our channel now. There it is. See, I'm proving to you. We got all 5. Don't miss an episode. And if you really want to get caught up, you can go to Courtroom Confidential live trials, and we streamed every day of it as well. So we got this one covered for all of you. But Haley was paying attention on day 3, and I said, there's no grand jury out here. That's why we're sitting through this whole thing, which leads Haley to ask a question we get every so often. What is the difference between a grand jury and a jury? I thought there was just juries. What we got different flavors of jury now? Yes, we do. The jury that you're most used to is the trial jury, or what is historically has been referred to as the petite jury. So we got the grand jury and the petite jury. The petite jury, which we now just call the jury or a trial jury, is for the purposes of trial only. They are sworn in at the beginning of a trial, and they are excused at the end of a trial. One trial. And they're to answer one specific question. Is the defendant guilty of the crime charged beyond a reasonable doubt? That's it. It's usually, depending on the jurisdiction, anywhere from 6 to 12 people. And they are considering a process that is adversarial. What I mean by that is that they're considering evidence presented to them by both the prosecution and the defense. Okay. We all know this. We've seen this. We've watched many trials, and that's the jury we're talking about. What you've never watched, though, is a grand jury, because one of the distinguishing features of a grand jury is the process is secret. There are no cameras in the courtroom. There never will be any cameras in the courtroom. And they're doing something else entirely. First of all, they're more than 12 people. Usually they can get up to 20, 30 people, depending on the jurisdiction. That's why they're called a grand jury. And they are for different purposes. They are most times that we talk about it in a criminal context for indictment. So you put to the evidence in front of them. The evidence that you saw over the last week in the Tyler Robinson prelim would have been the same evidence presented to a grand jury. It just would have been done far quicker because it's only the prosecution that's present. It's not an adversarial process. The defense is not present at all. Sometimes they're present, but they don't participate. The prosecution just presents the evidence that they have. And the question at the end of all of it is there enough probable cause to hold this person to answer? A much lower standard for the grand jury. They're not being asked beyond a reasonable doubt. They're just being asked, do you have probable cause to believe that this person committed this crime? And if you do, we're going to indict that person. They return a bill of indictment. Other distinguishing features of them is that they are they can sit and hear several different cases. They sit for a period of time rather than one. You don't reconvene a grand jury for every indictment. They might sit for a month or 60 days and hear several cases for indictment during that time. Again, they're in secret. The prosecution is the only one there. The prosecution essentially is kind of wearing two hats to some extent. The prosecution is supposed to present some evidence that is exculpatory if it's kind of obvious. One of the biggest complaints from defense attorneys is this, they don't do a good enough job with that. That's why you may have heard the phrase before, you can indict a ham sandwich, because it's kind of a one-sided process. Why do we do this, though? Why do we have this thing called a grand jury? Why do we have these things called prelims? Because the Constitution requires a probable cause determination as part of due process. It all comes back to this. When we drafted the Constitution and the amendments to it, we were sick of the criminal process taking place at that time. We didn't want people being arrested and held for months on end, if not longer. And then they get to trial and you realize this was just because the local sheriff had a problem with that person. And that person really didn't do anything. And you put the evidence in front of a jury and there's nothing there. So we say, listen, enough with this. We're going to have some sort of probable cause determination. It's not going to be determining that they committed it beyond a reasonable doubt, but somebody needs to take a look at this, an objective person, a judge or a grand jury, and objectively decide, is there enough evidence here to hold this person to trial? We're not going to decide it's guilty. We're just going to say there's enough here to bind you over for trial. And every single jurisdiction in the United States has some sort of process. Most of them are prelims. The vast majority are prelims. Prelims are usually quicker, but some places with the far more complex and intricate cases will institute the grand jury. I think in the OJ case, they started the prelim, and then it became such a circus that they actually went and indicted him by grand jury. Somebody fact check me on that. In the recesses of my sleep deprived brain, I feel like that's true. But I think they decided midway through the prelim to just indict him by grand jury because they just needed to get it done. Great question, though, Haley. I appreciate you asking that. Haley from No Location, please come back again. All right. Where are we off to here?
Hey, Josh, this is Gloria from Tampa, Florida area. I just had a question from something you said Wednesday night. You were mentioning the defense attorney Novak and how he might have represented the Menendez brothers back in California. And now we know Kathy Nestor is public defender. Can Tyler Robinson have both of those, a private attorney and a public defender? This defense is amazing, as you said. I don't know if I misunderstood what you said, but that just sounded very odd to me. But what a hearing this is turning out to be. All right. Thank you.
Thank you, Gloria from Tampa, Florida. Let's put you on the map. Appreciate you calling in. Yeah. So one thing I think it's important to clear up, because a lot of people have wondered about this, is how did Kathy Nestor get involved in this whole thing? Where did Richard Novak come from? Where did all those attorneys come from? I thought this guy didn't have any money. He doesn't have any money. This was interesting, and I found this out while I was in Utah. Utah has a public defender's office. Constitutionally, you're required to have some sort of mechanism to provide indigent defendants with an attorney. When we talk about your Miranda rights, if you have you have a right to an attorney, and if you can't have one will be appointed by you. That is a constitutional right according to the Supreme Court. So every county has to come up with something to do with that. In the bigger counties, you will have an entire taxpayer-funded office, the public defender's office. That's all they do all day long, is they are appointed to cases where people can't afford an attorney and they defend them in court. In Utah, they have a public defender's office. However, they did not either renew or have a contract for in the county that they're in. It's Utah County, not Salt Lake County. It's Utah County where this is taking place. Does not have a contract for public defenders to handle capital cases. So they have a public defender's office, but they won't handle capital cases. And I think that was a funding issue, a money saving effort. So when they do get capital cases, they need to appoint a private attorney who is death penalty qualified, who will then be paid on a agreed upon rate by the taxpayers of Utah. So I imagine they thought to themselves, this isn't going to come up all that often. And when it does, it probably won't be all that expensive anyways. And like all best laid plans, it's coming back to haunt them. So they needed to appoint him an attorney. So Kathy Nestor is an attorney who is death penalty qualified in the state of Utah. My understanding too was this case was shopped around. Like there were other death penalty qualified attorneys that were asked if they would take this on who said no. I spoke to one of them. This was a case that like a lot of people were like, I don't want anything to do with this, realizing the kind of public attention and political kind of heat that surrounds it. Well, Kathy Nestor said, sure, she'll take it. A part of that, she also the court is appointing co-counsel for her. So Richard Novak is a private attorney, but he has been appointed by the state of Utah. He is getting a paycheck from the taxpayers of Utah on that agreed upon rate. I don't know what that rate is, but just like Kathy, she said, I need co-counsel. So, and this is the guy I want. So he was hired. And he's not the only one, by the way. The other day, and I forget the guy's name, they're arguing some sort of media issue. And they're like, Your Honor, our First Amendment counsel is going to hire this. And I remember turning to people who were in the room. I'm like, he's got a First Amendment attorney. The guy has $1 million defense team. Mark my words. What was the figure that just came out for Brian Kohberger? I think it was north of $5 million that was spent on his defense team over the course of those years leading up to the trial. This is easily going to be that amount of money. Easily. And if it goes to trial, more. Millions are being spent on this defense. Now, listen. Not all of that is going into Kathy Nestor and Richard Novak and who else's pockets. Some of it's going towards experts, and some of it's going towards investigators, and some of it's going towards other related costs. But the lion's share of these billable hours are going into their pockets. Now, I am a defense attorney. Defense attorneys should be paid. I agree with that. I'm not begrudging attorneys getting paid. They're doing a heck of a job too. I mean, they are being incredibly litigious in this whole thing, but they're getting paid by the state of Utah. Now, they're probably going to tell you if they were here right now, well, I'm not getting paid what I usually get paid. True. I'm sure it's at a reduced rate to what they normally get paid, but they're getting paid. My question, though, and I'm just kind of throwing this out there to start a fight, is the Constitution guarantees a person who can't afford an attorney, but I don't know anywhere in there it says, and you can also get an attorney team well beyond what most people could afford. Like, if Tyler Robinson could afford an attorney, he'd get one, and it would be whatever he could afford, and it would not be this team. So tell me how that's fair, right? If you got a little bit of money, you're stuck with who you can afford. If you've got no money, you get the dream team who's making, got 3 different attorneys assigned to the case and probably more, and it's going to cost millions of dollars. Brian Kohberger didn't pay a penny for the $5 million defense he got. Had Brian Kohberger not been declared indigent, he would have afforded whoever he could have afforded. You following me on this? Something somewhere is not fitting for me on that. Anyhow, please discuss amongst yourselves. All right, let's keep it rolling here. Court Dog Daniel says, Josh, did you get a chance to get that Navajo taco? Dude, I barely got a chance to tinkle while I was there. If not, me and my RV will probably be in Provo in September. I'm buying tacos. I will happily take you up on that, my friend. K Dubs, thank you so much for the gifted memberships. Really, really appreciate that. All right. Oh, did we hit the 600? Nice. Well done, everybody. All right, I'm losing my place. Where are we at here? Here we go.
Hey, Josh, this is Rachel B. So For Real, your second favorite therapist in the chat. I'm calling from the Philadelphia area. So I have a situation that I came across the other day, and I'm wondering what your thoughts are on it. Imagine a couple of cops come across an abandoned book bag and jacket outside of a store. There doesn't seem to be anyone around. They look and no one's there that can claim these items. So they search through the backpack and through the jacket. They find an ID. They find a significant amount of illegal drugs, and they find a knife. What would you presume the police would do with this information? Would they go and find the person who the ID belongs to? Is there anything they can do at all? If they find this person, is it likely that charges would be pressed, considering the person did not have actual possession of the items when they found them? And if this was taken to a trial, what do you think the problems would be for the prosecution? And what do you think the problems would be for a defense, if this ever even amounted to anything? Thanks so much, Josh.
Rachel from Philadelphia, PA. Thank you so much for calling in, Rachel. I've said it before. I'll say it again. We got the smartest community on YouTube. I love this question. It reads like a law school question. So let's break it down. First of all, are the police allowed to? So you've got a bag, and I think you said it's got an ID. I like that added detail. It's got an ID, it's got drugs, and it's got a knife. So we've got possible way to identify the ownership. We've got evidence of a crime in the drugs, and then we've got evidence of a potential crime with the knife, right? What are they going to do with it? Well, can they search it, first of all? Well, if it is considered abandoned property, there is no probable cause required. So you throw something in the garbage that's abandoned, they can search that. Now, what about items left behind? Well, it really comes down to whether or not there was an expectation of privacy in that item. So here's an example. If somebody leaves a bag discarded in the street like you described, and it's been there for quite some time, there's the argument for that has been abandoned becomes greater and greater. If certainly you could see how it got left there, if a person was running away and threw it into a bush, that's certainly considered abandoned. But what about luggage left behind at the airport and it's just going around and round in circles at the baggage pickup? Is that abandoned, or is that somebody who forgot about it, and still could reasonably claim an expectation of privacy in that item and not necessarily abandoned it? So that would be kind of the first inquiry, whether or not they can even search it. Then your next inquiry is, what are they going to do with it? Now let's say it's the court believes that it is abandoned property and they want to do something with it. What can they do with it? Well, I agree with you. There's probably problems. If you take the ID and you show up to the person's house and you go, hey, did you leave this bag behind? We found your bag. And they go, oh yeah, that's my bag. Okay. You've established that. Next question from a savvy investigator might be, okay, well, I just want to be able to confirm that this is in fact your property. Can you tell me what was inside? And they go, yeah, my kilo of cocaine and my knife was inside. Now you probably got a rock solid way of using that. But short of that, a defense attorney is going to go, hey, listen, you found my client's stolen bag that happened to have their ID, and the same robber that took their bag also stuffed their cocaine in there along with their knife, and that's not my client's. That's going to be a big problem. Let's add the wrinkle of, what if there's blood on the knife? Then what do they do? Now they got themselves a real problem, right? They can't just ignore that. They probably would ignore it if it was just, as you described, a knife, some drugs, and an ID. Maybe they try to get creative and see if they couldn't get somebody to fess up. Maybe they go as far as dusting or swabbing the bag of cocaine. But if there's blood on that knife, I think you're going to see a little bit more investigation put into that, because now we're looking at evidence of perhaps a very serious crime. Great question, though. We could talk about this one for a while. That is Gloria from, no, pardon me, that is not. That is Rachel from Philadelphia. So thank you so much, Rachel. All right. Let's keep it rolling here.
Hey, Josh, it's therapist from West Texas. How is it not constitutional to play someone's confession to a crime before the trial? I don't understand. Thanks. Bye.
TYK from West Texas, everybody. There she is. Great question. I think I hope that you are asking this in reference to the Tyler Robinson case, because I'm answering it in reference to the Tyler Robinson case. Oh, no, not yet. We're almost there. Why didn't they play? Why was there such a problem about the playing of the confession? You heard Richard Novak. I don't know if this guy ever listens to our channel. I hope not, but he's really starting to grind my gears. He just, whenever he gets up, I'm just like, oh Lord, this is not going to be quick. When Richard gets up, it is a good time to go take a potty break, because you're not going to miss anything. By the time you get back, he will still be going. He took great offense by the idea that they wanted to play the interview, because the interview with Lance Twiggs included what he says the prosecution has described as a confession. And I screamed at my computer screen, so what? And his position is, listen, Your Honor, if it gets out there that Tyler Robinson, our client, admitted to this crime, it is going to so poison the potential jury pool that we will never get a fair trial in the county of Utah. That argument only goes so far, okay? There is extensive media coverage on many different cases that also sometimes includes confessions. And you know what we do with those? We don't throw them out of the county, we handle them. We have a process here that's been around for some period of time that handles that exact situation. It's called jury selection, where we go through extensive voir dire, which means you talk to people. Perhaps you even hand them a jury questionnaire where you thoroughly vet them to make sure that they haven't been so flooded with information about this case that this person's not going to get a fair trial. Utah County is not the biggest county in the US, but it's also not a tiny place. There are going to be plenty of people who can sit on this jury. I'll tell you how I know that, because while I was out there, I would ask people at the coffee shop or, you know, hanging out wherever I was, if, you know, the waiter at the restaurant, if they were aware of this case. You'd be surprised at how many people go, oh yeah, that thing. I don't know. They don't know. People got their lives going on. Not everybody is on Courtroom Confidential. Now, that's a real shame, but not everybody's following these things as closely as we are. And they kind of got their own stuff going on. And even if they have heard about it, it's not so etched into their brain that they can't sit on a trial fairly. So they tried to make it sound like the confession itself somehow made it uniquely inappropriate to play in court. That's hogwash, okay? And in fact, they did play it. That part was included in the video that we saw in court, where he said he confronted Tyler Robinson. Lance Twiggs says he asked Tyler, was everything he said true? He said, yes, everything I told you was true. And he even began to cry about it. And he said that he regretted it. That's a confession. 4 of them. By my count, 4 different ways in which he's confessed to this crime. Great question though, TYK. That was a part that really kind of got me out of my chair. All right, now it's time to bust out the hankies. Now it is. What are you talking about? You are not doing your counting right, lady. Okay. I love the fight that's taking place here. Go ahead. When are you going to say sorry? All right. It's the last 3, everybody. Here we go. Who's bringing us home?
What's up, y'all? Court Dog Daniel here. Josh, I figured you needed a break from the frustrations of the evidence decisions in the Robinson prelim, so here's my distraction for you. I've been rewatching the condensed Casey Anthony trial, and by the way, if you've never watched a trial that way, I highly recommend it. They edit out all the dead space like sidebars and repetitive admonitions so you can really focus on the testimony. Anyway, so I noticed something pretty cool. The prosecution kept bringing George Anthony, Casey's father, back to the witness stand over and over again. He'd testify, leave the stand, other witnesses would come in, more evidence would be introduced, and then they'd recall him later to testify again. So it got me wondering if it was a deliberate trial strategy. It seems they do that a lot with lead detectives and case agents, but it was strikingly fascinating to me to do it with the defendant's father. So is there an advantage to breaking up a witness's testimony and bringing them back at key moments after additional evidence has been introduced, rather than asking everything during one long examination? I imagine the defense hates this strategy because if it's like a super credible witness, they just keep coming back over and over. So what's this about, man? And in your years on both sides, did you ever intentionally structure a case that way, especially with a non-law enforcement witness? We'd love to hear about it. And therapists, you know, how many days till CrimeCon? Juice!
CDD from New Britain, Connecticut, everybody. Court Dog Daniel coming with the deep cut. Casey Anthony. That's on one way back on one of our previous albums. Casey Anthony. Haven't thought about this one in a while. Good reason for that. Try not to think about this lady as much as I can. Obviously found not guilty for the murder of her 2-year-old daughter. 2 years old. Oh, God. I don't care how long it's been. This is a rough picture to take a look at. Our littlest is about to turn 2 pretty soon here, and I just can't imagine. 2 years old, June of 2008. That's how far back we're going. We're getting close to 20 years on this thing. Isn't that crazy? Orlando, Florida. She didn't report her missing for 31 days. How they did not convict this woman for that alone is still beyond me. Well, Court Dog Daniel loves to self-flagellate. Is that it? I think that's right. And so he watched the condensed version of this trial. I've never heard of that. I do think that's kind of interesting, though. Who puts that together? Where you cut out all the kind of nonsense and just watch the trial quickly. That's interesting. And I don't remember this happening. So I'm going to just take you at your word that they called George Anthony, her father, on several different occasions throughout the trial. Okay, to answer your question, I've never done this, and it's very, very rare. And there's some good reasons for that. But I feel like I remember in the prosecutor's office that they were going to do that in one case in particular, not involving a law enforcement witness. And I remember thinking like, oh, that's fairly strategically smart. But you got two things. One, you got to get the judge to agree to it. Because a lot of judges are going to go, we're not playing games here. Call your witness and ask them everything you want to ask them. We're not doing this piecemeal. But it can create this powerful narrative to continue to call a witness back almost as if you're performing rebuttal in real time, right? So you've got maybe the defense asking certain questions of the witness, in cross-examination. Hold on, guys. Sorry. That you want to handle as it's happening. So you just call back another witness to rebut that. Usually you do see that with law enforcement. I have called my investigator more than once during my case in chief. And that's usually because the guy's sitting next to me. When you've got a civilian witness, you got to make sure that's somebody who's on hand to be recalled several times. And then you got to kind of explain to the judge why you're not just asking them all these questions as they're happening. Mostly what you would do is call the witness, ask them everything you feel like you need to ask them. If there is a reason for them to clean up what's ever happened during the trial, you call them on rebuttal. Or if you don't want to take the chance, I guess that could be another reason of the defense not calling anybody in their case, and therefore you're never going to get a chance at rebuttal. Maybe you call them again towards the end of your case to essentially perform some cleanup. But it's very rare. And I was not, that was, like I said, we're going on 20 years, not something I had remembered taking place. So thank you for bringing that up, Court Dog Daniel. Very interesting little wrinkle in that case, amongst other things. Jose Baez, by the way, was her attorney, who we're going to see in action again in the Shanna Gardner case, if that ever gets to trial. All right. Who's up next here for us?
Hi, Josh and Courtroom Confidential crew, mods, everybody. I hope you had a great week. I am calling in reference to the Charlie Kirk assassination hearing. And my questions are, does the judge have the ability to unilaterally make a decision at any time? Like just say, I've heard enough for probable cause. Let's keep moving. That was my first question. And my second question is, why do you think that he's not going to make a decision on this until September? That seems kind of weird to me after hearing the evidence all week. Just thought I'd run that question by you and say hi from Flowery Branch, Georgia. Bye-bye.
Michelle from Flowery Branch, Georgia. Let's put you on the map. Did I say flagellation? I think I said that right? Right? Self-flagellation. I just want to make sure I didn't say another word that sounds very similar to that, but that's what I meant. Michelle, Flowery Branch, Georgia. Let's put you on the map. You asked a couple of questions here about the Tyler Robinson case, which a lot of people were wondering, myself included. Therapists, you know, that's what I'm talking about. That's not what I'm talking about. Does the judge have the ability to make a decision at any time? The answer is yes, but the answer is also, but a judge would rarely ever do that. I have had prelims I've done, and I'm not trying to say this to brag. It's just in my career, I've handled hundreds of prelims, hundreds, literally. And many of them very, very short. And I can remember, a handful of times where a judge has kind of looked at me and went, counsel, we're done. Do we really need this next witness? To try to move things along. But in a case like this, with as big as it is and the amount of attention on it, the judge was not going to step in. Even when the defense was calling witnesses that weren't even helpful to the current inquiry, they're calling witnesses that are trying to kind of cross-examine and impeach the DNA evidence and the ballistics evidence, and the prosecution, to their credit, stood up and go, what are we doing here, Your Honor? This is a probable cause hearing. We don't need to hear from these witnesses now. These are trial witnesses. And the judge said, no, I'm going to let them do that. I think more of that should have been done. I think an offer of proof should have been taken on every one of their witnesses, and the judge should have ruled that they're not going to be called. But he allowed them to do it, okay? To your other question, why are we waiting until September? Well, I present to you the prior 10 months. Everything on this is just bigger and longer than it should be. I'll tell you what's even crazier. He's given it till September. Now, I understand this coming week he had conflict issues, but he's giving it till September. Maybe that's just a scheduling thing. But in the meantime, he's put them on a briefing schedule. That is just so extra on this. You don't need a briefing schedule. You argued the thing. He's heard all the evidence. One side stands up and goes, Your Honor, we presented evidence to you that certainly reaches the probable cause standard. The other side stands up and goes, nuh-uh, and the judge makes a decision. But to put it on a briefing schedule, the prosecution has to file a brief, the defense is filing a response, and the prosecution's filing a reply. My only thought was maybe he's doing that so that they get all these arguments out of their system and he doesn't have to listen to them in September because he's limited them to 2 hours. And I pray that that's true. But I also know these attorneys, and I don't care what they put in paper, they like to hear themselves speak. So that's what we're all in store for on September 1st. And by the way, I don't think he made it abundantly clear that he's even going to rule on that day. But we're all coming back in September. I'll probably be back in Utah if I had to guess. All right, now, boss lady, we are on to our final caller of the day. And I wanted to save this one for the last. So here you go. Turn your volume up, everybody. Oh, of course, I set that all up and then I got a technical issue. Here you go.
Another week of twists and turns, new arrests and bridges burned. Courtrooms filled with truth and spin. Which case do you think we'll see win? One more week, one more surprise. Alibis and courtroom lies. Lawyers spar while juries wait. Justice rarely keeps a date. Coffee's brewed, I'm all juiced, and the docket's long. What did we all get wrong? Poor Marley. Went to Six Rock Shore. The boat sailed off, she was no more. 5 days passed before she'd be found. A tragedy that shook the ground. Now Poot wants 12 months more to wait, says memories failed at this late date. The trial's on tape from end to start. Bench watcher Dick, refresh your heart. Ask Becky too, who dropped the ball. Her trial book might help recall. Then Harvey's inbox day by day finds ransom notes that come his way. Reuters said they're all fake, the FBI said. Hold the break. What a week in true crime's lane. Truth and fiction ride one train. Can't wait to hear your take on all of it.
That was fantastic, wasn't that? Here's our caller. Oh, is it not playing? Oh, I'm sorry, guys. Hold on. Oh, I see what happened. I know. Sorry.
Hi, Josh, Courtroom Confidential, Tiff, all the moderators and friends. I forgot to add with my rhyme that I'm from the southernmost tip of Africa, Lagalas, and it's bitterly cold here. Ciao.
That was JQ. There she is. JQ4444 from Lagalas, South Africa, right on the very tip. And I don't know why in my head, I'm like, it doesn't get cold in South Africa, but that makes a heck of a lot of sense way down there. What a beautiful poem. That is a banger. I loved it. That was fantastic. It almost like I wanted to almost hear it to like a minstrel, like what are they playing? A mandolin? Something. I don't think it's a mandolin. A lute. I think they're playing a lute. It's to a minstrel's lute is how I imagine that in my head. Thank you so much, JQ. I thought that was the perfect way to end today. You all have been fantastic, though. Thank you so much for joining us over the past couple of hours. Let me give you some quick announcements and get you guys out of here. Don't go anywhere because I got some stuff I don't want you to miss. One, let me tell you about a website really quickly called thecourtroomconfidential.com. At thecourtroomconfidential.com, you will find the following 3 M's. 1, messages. If you listen to the messages today and you thought those questions were great, but I want to ask my own, go to thecourtroomconfidential.com and click on leave us a message right over there to the right, that bar, and you can leave us a message for next time. And I will do my best to answer your question at the next Sunday Funday. 2, membership. A lot of you received gifted memberships today. A lot of you gave gifted memberships, and we're very grateful for that and for your support of the channel. But if you didn't receive one, don't get discouraged. Just go to thecourtroomconfidential.com and click on join the crew. It's the best and easiest way to join our membership program. And we put a lot of effort into it, by the way. One of the best benefits is every Thursday, you will have the hottest new show on YouTube, but it is a members only exclusive from Courtroom Confidential. It is Tea Time with Tiff every Thursday here on Courtroom Confidential. And you can get many of those benefits for just the low price of $2.99 a month. I feel like that is small change to be asking for all that we put into it. JQ says, I feel so filled with happiness right now. Thank you, everyone. I wanted to be part of this group for so long. Oh, well, thank you so much for that kind effort that you put into that poem. Minstrel. Yeah, I gotta find a lute. Let's find a lute player. Can we? Who plays the lute? Let's go online and find a lute player. And then finally, merch is the other thing that you can find. The 3 M's on thecourtroomconfidential.com. Click on our shop if you like this shirt I'm wearing today or any of the other colors and designs that we offer. Plus, we just launched our summer merch. Who is it calling from Budapest saying that she's only 80% juice because it's so hot. Was that right? From Hungary? Both of you are staring at me like you don't know what I'm talking about. Well, you know what you need is you need your summer survival kit from the Courtroom Confidential. We've got shirts, we've got tote bags, we've got koozies, we've got pajama pants, we've got beach towels. We've got you covered for all of your, we've got these slides for all of your Courtroom Confidential needs or summer needs from Courtroom Confidential. All right. What did you miss? Well, this week, like I have been telling you, we've done a live recap every single day of the Charlie Kirk, Tyler Robinson prelim live from Provo. So every single one of those episodes last week, please check out. Or if you want to just watch the live stream, check that out on our sister channel, Courtroom Confidential Live Trials. We were covering every single day of that. Also, if that's not enough for you, on Fox Nation, we did a live show every evening where we recapped what took place that day alongside my co-host, Donna Rotuno and Paul Morrow. It's a special called The Murder of Charlie Kirk on Fox Nation. Check it out now if you'd like to. Then stay tuned. This is a fun one. Tomorrow night, we are having a special guest who I'm very excited about. It is Greg Hartley from the Behavior Panel is going to be coming on 5 p.m. Pacific, 8 p.m. Eastern to talk to us about his analysis of Lance Twiggs' testimony. I thought that would be very cool to just see, is there anything else to be drawn from the not the sign language, from the body language and perhaps the phrasing and the use of words from Lance Twiggs. So we'll get into all of that tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern, right here back on the channel. Then we're back here again on Wednesday, same time, 5 p.m. Pacific, 8 p.m. Eastern. Friday, here's something special we have coming up. We have put together a multi-part series. We wanted to do kind of a look back on the Bryan Kohberger case, but through the minds of people who were heavily involved in it by doing these kind of sit-down one-on-one interviews. So we're starting that this coming Friday. The first episode will be with an extensive interview with Kevin Fixler. You all know him from the Idaho Statesman. He was probably the lead investigative journalist on that entire case. That will premiere this Friday at 4 p.m. Pacific, 7 p.m. Eastern. Then this Sunday, part 2 of that is with Joseph Scott Morgan to help us kind of walk through all of the forensic and medical examiner aspects of the Idaho 4 case. That will premiere on Sunday at 9 a.m. Pacific, 12 p.m. Eastern. So we'll be telling you more about that in the week to come, but I just wanted you guys to be clued into those special projects that we've been working on. Finally, one more announcement. This was something fun that came up within the last week or two, and I wanted to share it all with you. But if you've been to CrimeCon, well, you haven't really experienced it until you've been in the middle of the ocean while you're at CrimeCon. So coming up November 18th through 22nd, yours truly will be at the Crime Cruise 2026, November 18th through 22nd. I know. We will be cruising from Florida to Cozumel, Mexico, and back again. It's a 5-day cruise. All the details are on, is it crimecruise.com? I think that's it, right? Crimecruise.com. Please check that out. And along with all of this, we said we would be overjoyed to do it. But I had one request, and that was please give me a discount code so that I can tell everybody who might want to join us from the Courtroom Confidential crew that they could get 10% off. So if you enter the code Ritter, is it all caps? All caps, all one word, 10% off of your badge. The other speakers, this is a real great list of folks too, are going to be Chris Hansen, may have heard of him, Dr. Catherine Ramsland, Nate Eaton, good friend of the show, and some newbie pushover named Matt Murphy will also be there. So please check it out. I'm not sure if they're going to do any kind of streaming of it, but we're looking forward to it. I haven't been on a cruise in forever, and Tiffany's never been on one. So she's already been practicing her shuffleboard skills. That will be this November. Please check it out, everybody. All right. That's all I've got for you. Let me give a very special shout out and thank you to our mod squad, Afton, Sonia, Kathy, therapist, Bess, Nancy, and Becky B. You guys are rock stars, and I appreciate every single one of you. Kaylin, the biggest rock star of the group, thank you for putting up with me and being my therapist, I feel like, on top of it all. You're fantastic. And Tiffany, you are the best thing that ever happened to me. We will see you all here tomorrow night, everybody. Take care. Bye.